The Hidden Scrolls. Chapter 8. Judgment Day. The trial that began in a stark Jerusalem courtroom on the first day of February 1993 was a private civil action, a claim for monetary compensation and vindication of injured personal honor. Yet Professor Alicia Qimron's $250,000 copyright infringement suit against Herschel Shanks, Robert Eisenman, James Robinson, and the Biblical Archaeology Society clearly had a symbolic and emotional significance that far transcended the specific claims. Among the expert witnesses called by the plaintiff were Antiquities Authority Director Amir Drori and Shrine of the Book curator Megan Broshi, both of whom had long been primary targets of Shanks' editorial attacks. Also on the witness list were Professor Yaakov Sussman, who had worked closely with Qimron in analyzing MMT's historical significance, Professor Larry Schiffman, who had also been consulted by Strugnell and Qimron, and Professor Norman Golb, who disagreed with just about everything most other Qumran scholars had to say. The trial was thus eagerly anticipated as the scholarly equivalent of a steel cage match between the Dead Sea Scrolls rebels and the Dead Sea Scroll establishment. And while the 2 long days of the trial's direct testimony and cross-examination often proved more tedious than gripping, seats on the hard wooden benches of the spectators section in the Jerusalem courtroom became some of the hottest tickets in town. Herschel Shanks had no alternative but to defend himself against the lawsuit. Mobilizing his faithful readers for a new crusade to defend intellectual freedom, he announced the establishment of a legal defense fund and voiced his objections to both the aggressive tactics employed by Qimron's lawyers and the very contention, in light of the wide circulation of the pirated MMT transcription and its previous publication by Kapira in Poland, that the text had never been published before. Particularly galling to Shanks was Qimron's claim that he owned the copyright on the transcription. For Shanks, this claim was laughable. Copyright implied some act of inspiration and creativity, and if Qimron's transcription included correctly restored words and letters, the inspiration and creativity was completely that of the ancient author, not Alicia Qimron. In coldly translating his scholarly work into property rights that had a definable monetary value, Qimron was attempting something that the international team had never, in all its 38 years of existence, suggested. In the creation of the team in 1953, Pierre Deveau and Lancaster Harding had hoped to facilitate the editing process by restricting it to a small circle of dependable scholars who would presumably publish the text in the Discoveries in the Judean Desert series without expectation of direct personal reward. The Palestine Archaeological Museum itself received no royalties from the first volumes. There is no question that the international team members achieved great professional prestige and in some cases professional advancement. But if they sometimes greedily claimed more text than they could ever publish, if they selfishly held onto those texts while There were plenty of younger scholars who would have eagerly jumped at the chance to work on them. None of them ever, so far as I am aware, considered their reconstructed transcripts to be private property. If Qumran's suit prevailed in the court in Jerusalem, the official editor's reconstructions of all Qumran texts, and by extension all fragmentary ancient texts discovered in the country, would be regarded as copyrightable, ownable intellectual property. Once the exclusive right of first publication was granted to a scholar, no matter if it was granted through personal connections, under political pressure, or even by a fair evaluation of the skill of the scholar, his or her eventual reconstruction would become a personal possession, defendable in a court of law. Thus a dangerous precedent would be established in the determination that Elisha Qumran held the copyright on MMT. For the text to be legally reproduced, it would have to be done with Qumran's express permission, and as a copyright holder, he had absolutely no legal requirement to grant that permission to everyone. Would he be likely to grant that permission to some rival whose theories he despised and whose personal manner he detested? How would he be likely to react to an angry, impolitic letter from someone like Robert Eisenman? What would then happen to the deal of open discussion of ideas among the fellowship of scholars? These were precisely the questions that Shanks now used to formulate a new campaign for academic freedom. If anything is worse than refusing to allow the public to see the photographs of the fragments, he insisted in BAR editorial in the autumn, it is giving exclusive rights in the transcription of the ancient texts to the scholar who transcribes it. The Dead Sea Scrolls story had taken many strange twists since the sudden good fortune of Ahmad Mohammed, Khalil Musa, and Muhammad Dahib in the winter of 1946 to 47. But none of the reversals of fortune was as ironic as this. What would Père de Vaux or Lancaster Harding, both faithful partisans of the Hashemite kingdom of Jordan, have thought of the idea that the exclusive rights of the international team members would eventually be confirmed in a court of law in the State of Israel, with arguments, petitions, and summations delivered in modern Hebrew, presided over by a judge who readily admitted that she had taken the case because it concerned the heritage of the people of Israel. Neither Eisenman nor Robinson was present at the trial. Shanks had from the beginning taken full responsibility for the publisher's foreword, ready and determined to argue that Dead Sea Scroll texts did not belong to Qumran or to any individual scholar, but were the intellectual legacy of the entire world. For Shanks, this legal battle was now about more than free access to the Dead Sea Scrolls. It had become a struggle for the free interplay of ancient literature and modern ideas. Unfortunately, neither Shanks nor his lawyers could persuade Judge Dorner to sympathize with that transcendent ideal. The first witness was Megan Broshi, curator of the Shrine of the Book and member of the Scrolls Oversight Committee, who explained to the court of law how he had first introduced Qumran to Strugnell around 1980, how Strugnell had been utterly stymied in his study of MMT, owing his lack of halakhic understanding, and how Qumran had spent 10 years of his life toiling over fragments of the various copies of MMT in order to assemble the reconstructed text. When asked about the historical significance of the manuscript, Broshi had no doubt that Qumran had divined its true context, and he asserted in an imaginative, if implausible speculation, that if the contents of the text had not been revealed by others and Qumran had written a book for the general public about it, it might well have sold tens of thousands of copies by now. It was an assertion that strained even a willing suspension of disbelief. This about an ancient text that contained no sex, violence, or heretical secrets, by a scholar whose speciality was historical grammar, and whose writing style was as dry as the Judean wilderness. As Eisenman's attorney, Amos Hauser, later implied pointedly during his summation, MMT was not Masada, and Elisha Qumran was no Yigal Yadin. Then came Professor Jakob Sussman, Qumran's longtime associate, with another story to tell. Sussman rehearsed the significance of Qumran's work and MMT's interpretation as a precious evidence of halakhic discussion in the Hasmonean period. The irony is that everyone in the courtroom accepted that opinion as a definitive scientific explanation, a matter of indisputable fact. But at issue here was not history but money. Sussman raised eyebrows throughout the courtroom when he asserted just how significant he believed Qumran's monetary loss had been from the whole MMT affair. Its premature publication, Sussman claimed, had robbed Qumran of acclaim and thereby damaged his reputation. And since Sussman maintained in an enormous exaggeration, first-rank scholars with international reputations could earn as much as 5,000 to 10,000 per lecture. Qumran's loss was obvious. The slideshow went on for 2 full days, from morning until late in the evening, with Qumran offering his heart-rending story of a life of privation in the name of scholarly dedication, and how he now felt that his life's work had been stolen from him and his world had collapsed. Yet it was Shanks himself who sealed his own fate, being unblinkingly candid about his intentions and his beliefs, admitting that he had made a mistake in not acknowledging Qumran's contribution and in not paying enough attention to the restored words between the square brackets. He refused to concede that Qumran could claim any copyright. If any copyright should be granted, Shanks suggested, it should be granted to the teacher of righteousness. At this point, Judge Dorner directly intervened to ask Shanks what was perhaps the single most telling question. If he had known about the amount of painstaking work that went into Qumran's work of transcription and restoration, would he still have published the text? Shanks could have been contrite. He could have taken the easy way out and told everyone in the small courtroom what they wanted to hear. But it is to the credit of Herschel Shanks, especially in light of the latter costs and humiliation, that he stated plainly that, under the same circumstances, he would certainly do it again. The 44-page judgment issued by Judge Dorner on March 30 could hardly have been more stinging. This judge obviously didn't like me, Shanks later told me in a breathtaking understatement, and had no sympathy for the campaign, although Dorner acknowledged that Qimron's losses of book royalties and lecture fees were entirely hypothetical. She awarded him the maximum of the equivalent of $7,400 in punitive damages, because she resented the fact that Shanks saw this publication as part of an ethical battle and refused to acknowledge the damage he had caused Qimron. In addition, she awarded Qimron the equivalent of $29,600 for mental anguish, which was the largest ever awarded in Israel for a copyright case. Shanks would also be liable for about $18,500 for Qimron's legal fees. The tone of the judgment against Shanks was openly critical, and the sums were just large enough to be painful for the Biblical Archaeology Society. Yet, even worse for the future of Qumran scholarship was the fact that Judge Dorner significantly expanded the legal copyrights of the editorial team. Despite Shanks' contention that a text once published could be used freely by other scholars as the essential foundation for further scholarly discussion and research, Judge Dorner ruled that there is no evidential support for the scholarly convention, and even if there were, there would be no support in law. Publication does not cancel copyright. Neither law nor custom allow the unauthorized reproduction of material that has already been published, and when it is legally used, it must be used as a quotation citing the original author. What all this meant, of course, was that the first editor of the text could control its future use, thus coldly turning her back on her avowed interest in the shared heritage of the people of Israel. She cast into doubt the new regime of open access that Shanks had fought so hard to achieve. Qimron was now in a position to sue anyone who published unauthorized transcriptions of MMT that resembled his own. Rumors spread of his intention to sue Abegg and Wacholder and Eisenman and Weiss. Just a personal footnote, I think it's a strange coincidence. The name would be Qimron, Qimron. I mean, that's just weird. Whether it's real or not, I wouldn't suggest that it wasn't, but that's just a weird coincidence. Some sort of emotional element added to the case. I don't know. That's just weird. Anyway, continuing. If you want to talk about a chilling effect, this was certainly one. The ominous mix of copyright law and Qumran scholarship was a subtle way of preserving the hierarchy of power by making the publication of alternative reconstructions of Qumran, spelt Qumran, texts by any outsiders a matter of some legal sensitivity. With copyright now an issue, an unauthorized editor would have to prove that he or she was completely unaware of the official editor's views on a particular document. And that would be impossible in the small world of Qumran scholarship. Scroll's editor-in-chief Emmanuel Tove, reacting to Judge Dorner's decision, was clearly gratified that the critics and usurpers had been put in their place. "This will serve as a precedent for the future," he declared to the New York Times correspondent Joel Greenberg. "It justifies the work of our team, and I hope that other people planning to make improper use of the group's material will now think twice." If Herschel Shanks had been put in his place, at least temporarily, Robert Eisenman continued to be ostracized. The reviews by Qumran scholars of the Dead Sea Scrolls Uncovered continued to be vicious, and his historical ideas continued to be dismissed out of hand. In late May, when I spoke with Tove about the progress of the publications project, he expressed clear regret that the uproar of the previous few years had ever occurred. I think that in many ways it would be much better for us had this not taken place, he told me, with a definitiveness I doubted. I have a feeling, or I know, I would say that all of us members of the team would have done exactly the same scholarly work and in a much better way had these external disturbances not taken place. There is no question that Tove has succeeded in organizing and supervising the work of the Publications Project in a manner that will ensure the publication of all the remaining Qumran Cave 4 material within just a few years. Already several new volumes of the Discoveries in the Judean Desert series are in advanced stages of preparation. It is his hope that all the material will be submitted to him by 1997. In sharp contrast to the wide variation in length and detail of the earlier Qumran publications, Tove has tried to establish uniform guidelines, at least in the style of transcription, translation, and commentary, for the material to be received from the dozens of scholars in Europe, America, and Israel who have allotted unpublished texts. And now, in an age of personal computers and desktop publishing, he has been able to prepare camera-ready pages of scroll text and commentary to be sent directly to Oxford University Press.